All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Would the court officer please call the case?
Good morning, Mr. President. Situation in the Republic of Uganda in the case of the prosecutor versus Joseph Kony, case reference ICC 02040105, and for the record, we are in open session.
I am Judge Ertan Basun Damdim, presiding in this appeal, rising from the case of the prosecutor versus Joseph Kony. My fellow judges in this appeal are Judge Salome Balunga Bossi, Judge Kimberly Prost, Judge Jonah Corner, and Judge Gocha Lord Kipanidze. I note for this record the presence of the defense team and the Office of Public Counsel for Victims and the Office of the Prosecutor. I take it that the attendees are the same as the ones appearing in the list of which the court officer kindly provided to the appeals chamber before the hearing. If the composition of any teams has changed, please notify the court officer by email. Today, the appeals chamber will deliver its judgment in the appeal of the defense for Mr. Kony against the decision of the pretrial chamber 3 of 29 October 2024 entitled Decision on the Criteria for Holding Confirmation of Charges Proceedings in Absentia, which I will hereafter refer to as impugned decision. In that decision, which bears the document number 532 in the case record, the pretrial chamber found that all requirements set forth in the Article 61(2)(b) of the statute were met and decided to hold the confirmation of charges hearing in the case. This is non-authoritative summary of the appeals chamber's written judgment. The authoritative version is written judgment, which will be made available and be notified after this hearing. Now I will start with the brief background to the appeal. On 23rd November 2023 and on 4th March 2024, pretrial chamber 2nd issued two decisions concerning the prosecutor's request to hold a confirmation of charges hearing in absentia. On 21st June 2024, the registry appointed defense counsel for Mr. Kony. On 29th October 2024, pretrial chamber 3 issued the impugned decision in which it decided that Mr. Kony qualifies as a person who cannot be found and that an initial appearance in respect to such persons is not a requirement to hold a confirmation of charges hearing in absentia pursuant to Article 61(2)(b) of the statute. On the 4th November 2024, the defense requested leave to appeal the impugned decision. On the 28th January 2025, the pretrial chamber partially granted by majority the defense's request for leave to appeal, certifying the following issue: whether an initial appearance by the person charged is required before a confirmation of charges hearing can be held in absentia under Article 61 2b of the statute. On 7th February 2025, the defense filed its appeal brief against impugned decision. On 20th February 2025, the OPCV and the prosecutor filed their respective responses to the appeal brief. On 24th February 2025, the defense filed a request for leave to reply, which was partially granted by the appeals chamber. The defense filed its reply on 3rd April 2025. For the reasons that I shall proceed to outline, the appeals chamber rules that the impugned decision is confirmed. The appeals chamber will first address the main defense's arguments concerning the ordinary meaning of the terms of the Article 61 2b of the statute, raised under the second ground of appeal. Then it will address the arguments concerning the context of the provision as well as the object and purpose, raised under the first and second ground of the appeal. It will then address the arguments raised under the third ground of appeal. Under the second ground of appeal, the defense argues that pretrial chamber adopted an interpretation of phrase cannot be found, driven by its understanding of the need to distinguish it from its notion of fled. The defense submits that in requiring such a distinction, the pretrial chamber was guided by purported ordinary meaning of the term, or in Article 61 2b of the statute. The defense argues that the pretrial chamber erred in finding that only way to distinguish fled from cannot be found, maintaining them as two separate and distinctive alternatives, is to interpret a letter as not being subject to a requirement of initial proceedings under Article 60 of the statute. The appeals chamber recalls the outset that the interpretation of treaties such as the Rome Statute is governed by the Vienna Convention on the Law of Treaties, specifically by the provisions of Articles 31 and 32 thereof. Pursuant to Article 31 of the VCLT, quote, treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose, end of quote. The appeals chamber notes that the pretrial chamber referred to the ordinary meaning of the distinctive term, or which, in its view, is employed to connect situations, items, or sets of circumstances that are typically alternative to, and hence different from each other. On this basis, the pretrial chamber interpreted the phrase fled or cannot be found as necessarily referring to two different and independent situations. In order to differentiate these situations in a manner that makes them mutually exclusive, the pretrial chamber defined fled as referring to a person who was previously accessible to the court and absconded. In turn, cannot be found was defined as referring to a person who has never been accessible to the court and whose precise whereabouts were and remain unknown. It followed, in line with this interpretation, that the holding of an initial appearance could not constitute a requirement for a person who has never been accessible to the court. The pretrial chamber reasoned that, quote, any understanding would contravene the ordinary meaning to be given to the term or in Article 61(2)(b) of the statute as understood in its context, end of quote. Upon analysis of the nature of this distinction adopted by the pretrial chamber, appeals chamber notes that the word or can be used in an exclusive, also in an inclusive or weak sense to separate notions which are not entirely different and independent from each other. The appeals chamber finds that two meanings, inclusive and exclusive, properly fall within the ordinary meaning of the term or in Article 61(2)(b) of the statute. Taking this finding into consideration, the appeals chamber will now examine the defense's submission and the pretrial chamber's interpretation of Article 61(2)(b) of the statute. According to the defense, the distinction between fled and cannot be found does not depend on whether the person was previously made an initial appearance before the court, but rather depends on the reasons and willfulness for the person's non-reappearance. In the submission of the defense, quote, the term fled refers to a person who decides consciously to evade court's jurisdiction, whereas a person who cannot be found refers to a person who's otherwise unable to found for any other reason, including abduction, arrest, illness, or any other cause that falls short of willful evasion of the court's jurisdiction, end of quote. The appeals chamber notes that, contrary to the defense's contention that what is decisive in terms of the application of Article 61(2)(b) of the statute is that at the time of the proposed hearing, the person has fled or cannot be found despite all reasonable steps having been taken to secure his or her appearance. The reasons as to why the person either fled or cannot be found are not material. In a sense, the defense's interpretation places undue emphasis on the suspect's reasons for non-availability rather than the fact of unavailability. The appeals chamber considers the inclusion of this proposed distinction based on the reasons for non-availability is beyond the ordinary meaning to be given to the terms used in Article 61(2)(b) of the statute. The impugned decision defined cannot be found by reference to two factors. First, that the precise whereabouts of the suspect were and remain unknown. And second, that he or she has never been accessible. Of relevance to the issue before the appeals chamber, is the second matter. The appeals chamber finds no basis for this factor in the ordinary meaning of the terms. The statute uses the phrase cannot be found in the present tense and thus refers to the status of the person at the time of the confirmation of hearing. The provision does not require evaluating whether the person was ever accessible to the court previously. A person may qualify as someone who both fled or cannot be found without incurring contradictions. There is nothing intrinsic to the terms fled or cannot be found that makes them mutually exclusive. The appeals chamber found that to the extent that pretrial chamber based dispute findings on the ordinary meaning of the relevant terms, it was an error to consider that the phrase cannot be found only concerns person who have never been accessible to the court and who were thus unavailable for an initial appearance. In the view of the appeals chamber, the ordinary meaning of cannot be found does not support such interpretation. This error, however, has not materially affected the impugned decision. In conclusion, based on the ordinary meaning alone, it cannot be read into a phrase cannot be found that it only concerns persons who have never been accessible to the court. Similarly, the phrase cannot be found does not only concern persons who have not had an initial appearance. Rather, it applies to persons regardless of whether they have had an initial appearance. Accordingly, appeals chamber rejects defense's arguments above raised under the second ground of appeal. The appeals chamber will now assess whether or not requiring an initial appearance before the proceedings to a confirmation of charges hearing in absentia is consistent with the context and in line with the object and purpose of the statute. Under the first and second ground of appeal, defense alleges that pretrial chamber erroneously interpreted Article 61(2)(b) of the statute in isolation from Article 60 of the statute. The defense contends that Articles 60 and 61(1) and 2 of the statute require an initial appearance as a necessary and critical procedural initial step, regardless of whether the confirmation of charges be held in the presence of the person charged or in absentia. It submits that this is not affected by the term subject to the provision of paragraph 2 of Article 61(1) of the statute. The appeals chamber finds that defense misconstrues the relevant provisions of the statute. The appeals chamber has previously held that a phrase in a provision, I quote, must be read as a whole and in a manner that gives meaning and effect to all its constituent words rather than in disjointed manner, end of quote. The defense's suggestion to reconnect, subject to the provision of the paragraph 2, to the last sentence of the provision, the hearing shall be held in the presence of the person charged, incurs a disjointed reading of the provision. Read as a whole, the phrase in Article 61(1) of the statute provides that the pretrial chamber shall hold a confirmation hearing within a reasonable time after a suspect's surrender or voluntary appearance before the court, and that this hearing shall be held in the presence of the suspect, subject to the provisions of paragraph 2. Ignoring this construction would render the phrase subject to redundant and unnecessary, contradicting the very jurisprudence quoted by the defense, according to which the court must endeavor to give significance to every word in the statute. Appeals Chamber finds that, read in context, Article 61(2)(b) does not require the suspect's initial appearance prior to proceedings to the confirmation of charges in absentia. Contrary to the submissions of the defense, the initial appearance may or may not be required in the different scenarios set out in Article 61(2)(b) of the statute, with no inherent contradiction, contingent only upon the availability of the suspect. In relation to the object and purpose of the statute, the defense submits that ending impunity must be achieved through strict adherence to the provisions of the Rome Statute. It contends that the pretrial chamber has made an expansive and broad purposive interpretation of Article 61(2)(b) of the statute. The appeals chamber is of the view that the main considerations in the respect of whether proceeding without an initial appearance is incompatible with the rights of the defense, and whether the procedural functions that underpin the confirmation of charges herein are preserved. The appeals chamber finds that proceeding to an absentia confirmation of charges hearing without a suspect's initial appearance is not incompatible with the rights enshrined in Article 67 of the statute. The statute and rules provide adequately robust safeguards to protect suspects' fair trial rights, even in cases where such an initial appearance has not taken place. The appeals chamber considers that an interpretation that restricts in absentia confirmation hearing to unusual scenarios, such as when a suspect has previously appeared but then absconded, undermines the statute's broader aim to put an end to impunity. Additionally, such a reading does not offer any meaningful additional protection under the relevant provisions and does not deprive the person of any rights and guarantees which are fully available at trial. Appeals chamber finds that the holding of confirmation of hearing in absentia, even without an initial appearance, is consistent with the object and purpose of the statute. Therefore, appeals chamber rejects defense's arguments in this respect. Under the third ground of appeal, the defense claims that the drafting history of the statute and the rules show that the pretrial chamber's interpretation of Article 61(2)(b) of the statute finds no basis in the intent of the drafters. The defense submits that drafting history of Article 61(2) of the statute and Rule 122 of the rules supports that drafters intended to exempt the confirmation hearing, not the initial appearance, from the requirement of the accused's presence. The appeals chamber rejects this interpretation. The placement of the wording "subject to" at the beginning of the Article 61(1) of the statute, rather than the end of the provision, tends to suggest that very need for surrender or voluntary appearance are subject to provisions which regulate in absentia confirmation proceedings. For the reasons set out in further detail in the written judgment, Appeals Chamber rejects defense's third ground of appeal. This brings us to the end of the summary of the Appeals Chamber's judgment of today. For these reasons, and for the reasons stated more fully in the written judgment, the Appeals Chamber rejects the appeal and confirms the impugned decision. The present judgment is unanimous. I would like to end by thanking all the parties, attendees, participants, and their counsel and registry staff who have assisted with today's hearing. There is a lot of work that goes behind the scenes to ensure that these hearings run smoothly, and the Appeals Chamber is very grateful to all those involved. I would like to thank my colleagues, the judges, and the Appeals Chamber staff for their support.
All rise. Veuillez vous lever.